My name is Joshua Joytel. I'm a co-chair of the Defense Function Committee at ABA, and I'm a member of the Criminal Justice Section Council. We have a very distinguished panel that I will introduce here in brief, because if we went through their entire set of credentials, we'd take up all the time for the panel. So on my right, on my immediate right is Judge Denise Langford Morris, and she is the first African-American Oakland County Circuit Judge and the first female dean on the bench. She started as a protective services worker for mentally and physically disabled adults and senior citizens, and then for abused and neglected children. And in that context, she also obtained a Master of Arts cum laude in guidance and counseling from Wayne State University. She went to law school and received her degree at the University of Detroit Mercy Law School, and she's also a trustee of that institution presently. She was also a state prosecutor in Oakland County and an assistant United States attorney in the Eastern District of Michigan in the Civil Division. And she's obviously had extensive trial experience as both a prosecutor and a private practitioner. She has a wide portfolio of institutional leadership and responsibility. In the ABA alone, she's the director of the National Conference of State Trial Judges, the co-section manager of the Criminal Justice Section Equal Justice Division. She's co-chair of the Criminal Justice Section's Judicial Function Committee. She's a member of the Rule of Law Initiative Africa Council, and she's a member of the ABA Women's Task Force. She's also past chair of the National Bar Association Judicial Council, and a director of the Michigan Supreme Court Historical Society. So that gives you some sense of, and she also does work outside the legal community, Salvation Army, and other organizations in her community. So we're really privileged to have her here, and so glad she's able to join us on the panel. She's also won a lot of awards, the 2018 Women's Lawyers Award in Michigan, the Justice Mary S. Coleman Award, 2017 Career Master Distinguished Career Award, and awards from her alma mater, Detroit Mercy Law School, the Esteemed Woman of Michigan Award, the Bernstein Community Health Clinic Award. There's a whole paragraph here of her awards, and so, as I said, trust me. To Judge Langford Morris's right is Kevin Curtin. Kevin is the Senior Appellate Counsel and Grand Jury Director for the Middlesex District Attorney Marion T. Ryan, which is Massachusetts. He supervises grand jury practice, writes and supervises appellate briefs, conducts oral arguments, manages Superior Court post-conviction matters, and advises the District Attorney and Bureau Chiefs in that office. He is currently the Vice Chair of ABA's Criminal Justice Section Council and co-chairs the Criminal Justice Section Committee on Appellate and Habeas Practice. And he's had extensive experience in this particular subject matter, and I'll explain that later. But he's also on the Massachusetts Bar Association Criminal Justice Section Council, the Massachusetts Bar Association Civil Rights and Social Justice Section Council. He teaches at Trial Advocacy College at the University of Virginia, at the Harvard Law School Trial Advocacy Workshop, and also at Boston College. He's having a great award season, I would say, like up there with that movie Roma. He's really, he at the Massachusetts Bar Association Access to Justice Award in 2017, was named Prosecutor of the Year by the Massachusetts DAs in 2017, and received the Criminal Justice Section Norm Malang Minister of Justice Award in the fall of 2018. He's a 1988 graduate of Boston College Law School, and he also served as a clerk for the Honorable William G. Young in the District Court in Massachusetts, who has a lot of interesting and high-profile cases and opinions. And most impressive thing for me about why I admire Kevin the most is, since October, he has not once mentioned the Red Sox to me. So I give him tremendous credit for that. Anyway. And to Kevin's right is Christopher Lash. He's a professor at the University of Denver Sturm College of Law, and his legal scholarship has been focused on the entangling and disentangling of criminal and immigration systems, and he's written extensively on it in many distinguished law journals, such as the Yale Law Journal Forum, a common law privilege to protect state and local courts during the crimmigration crisis, And so that has been a focus of his scholarship for some time. And you'll also hear that he has also been involved directly with some of the issues that we're talking about, including a letter by 300 law professors on the issue of immigration enforcement in state courthouses. He's a Yale Law School graduate in 1996, and then he was a public defender in Louisville, Kentucky, and then a private lawyer in criminal defense and civil rights litigation. And in 2006, he became the Robert M. Cover Clinical Teaching Fellow at Yale Law School, where he taught numerous clinics, including the Worker and Immigrant Rights Advocacy Clinic. And he currently co-directs the Criminal Defense Clinic and the Immigration Law and Policy Clinic at the University of Denver Sturm College of Law. So we're really happy to have everybody here and get deeply into these issues. Now, the structure, what we'll do is each, oh, and also here, Lucien Dervin is here, our section chair, and Kevin Scruggs, who's our CEO of the section. So we want to thank them for being here as well, and also give them the credit for helping us organize all this and really making this possible through their leadership, and we appreciate that immensely. In terms of structure, what we'll have is each of the panelists will give us a short presentation about a specific area, because we tried to get different perspectives: judicial perspective, prosecutorial perspective, and also an academic perspective. I will follow up with some questions that I've developed and in talking to the panelists, and then we'll open it up for audience Q&A, which we hope to have a sufficient amount of time for. We'll make sure we have a sufficient amount of time for that. This issue is about what ICE, Immigration and Customs Enforcement, is doing in state courthouses across the country, and has been doing for a considerable period of time, but things changed in 2017. And the policy has been not to enforce absent exigent circumstances, which again is a rather broad exemption, but absent exigent circumstances, not to enforce or not to arrest people who are undocumented or subject to deportation when they are in sensitive locations. And the courthouses are not sensitive locations. So we'll have a discussion about that, and obviously what the fallout has been from the increased enforcement in state courthouses. So if someone shows up for a family court matter, let's say a mother shows up for a family court matter with respect to either domestic violence or something to do with her child, and she is arrested by ICE at the courthouse. Let's say a victim of a crime shows up at the courthouse ready to testify at a criminal trial, arrested. Let's say a criminal defendant has a Hobson's choice of, do I show up for my court appearance and risk getting arrested by ICE, or do I not show up and get a warrant for my criminal case? So these are all very important issues. And just to give you some statistics, from January 20, 2017 through the end of the year, ICE made 110,568 arrests compared to 77,000 in fiscal year 2016. That's an increase of 40%. The increase in arrests of people who had no criminal record increased by 146%. There's an ABA resolution on the subject, but for that we're going to have Kevin give us the background on the ABA resolution and some of these issues in a more granular way, because Kevin authored the ABA resolution that was passed in 2017. So, and that came out of the Massachusetts Bar Association as well, and I'll let Kevin take it from here.
Thanks, Josh. So I co-authored this with Raul Ayala, who is the Deputy Federal Defender from Los Angeles, seated in the second row here. And so this is a great collaboration between prosecutors and defenders, and on a subject where there's plenty of common cause. So I think you probably know, as practitioners, probably familiar with work in this area, but if you don't, Starting in 2014, 5 years ago now, the DC office of the ACLU made recommendations to the Department of Homeland Security that they ought to change their guidelines and regulations concerning where arrests are being made, because arrests were being made in and around courthouses. It was causing a chilling effect on people seeking the protection of courts, and anybody involved in court, in something that would require them to show up at a courthouse. And so that was 5 years ago. Nothing happened until the recent presidential election in the spring of the early spring, late winter of 2017. It became very clear that there was a deliberate decision that was being made to ramp up the enforcement actions at courthouses. And the reason that was given for that was because it was in, I guess, retaliation or in response to the actions of cities, municipalities in establishing sanctuary cities and trying to deter arrests for the status offense of being undocumented. And the courthouses were safe, and if they were looking for people who were criminals in their view and dangerous, then that would be the place to go to find people like that, particularly defendants. But what wound up happening is that it wasn't just defendants who were being arrested in courthouses. It was anybody that was being arrested in courthouses. We had in Massachusetts, the former president of our Mass Bar Association was in a situation where he had the opportunity to represent a woman who showed up to extend a civil restraining order that she had obtained against her abuser boyfriend, husband, who had been threatening for years that you can't go to court, nothing you can do about this, or I'll have you deported. So she shows up after 10 days after getting the emergency ex parte order to have it extended, and there is ICE, and they're waiting for her. And he had to get her away from the public corridors. He had to get her into a private room where she could not be seen. She then made the decision not to enter the courthouse to extend that abuse prevention order that she was seeking. That's a civil process. Meanwhile, her abuser, pounds his chest as he comes out of the courthouse. His case winds up getting dismissed or the civil case winds up getting dismissed when she doesn't show up to get it extended. And that's the kind of justice that we're seeing with the involvement of ICE without any kind of restraint, without any kind of guidelines on how and when they should be taking actions in courthouses. So what we considered was that it would be important to follow up with what the ACLU had recognized 4 or 5 years ago and to make a recommendation. There were 2 bills pending in Congress, a House bill and a Senate bill about amending the Sensitive Locations Act. That's a federal statute that provides guidance on when ICE enforcement actions can be taken in various places, and hospitals, places of worship, schools. Those are places that are designated as sensitive locations because they're sensitive locations, and you don't want to deter people, even if they may have the civil status of being undocumented, from going to a hospital or going to a place of worship or taking their kids to school. So why would you not extend that type of protection to people who are availing themselves of the protections of the courts? So that was that was not the only outcry. There was great public outcry across the country. There are chief judges from various states who took action. All they can do is send letters, asking, for further consideration or asking for restraint or at a minimum collaboration. California, Raul's jurisdiction, the chief judge of the state court wrote such a letter, and the state of Washington, the chief justice there. So there's actions on the judicial side to try to persuade ICE not to be doing this. There's proposed legislation that exists in many states, including New York, Josh's home state, as well as in Rhode Island and in other states, that is intended to curtail the authority of ICE to enter a state courthouse or premises in order to make these types of arrests. And so in 2017, this ABA resolution, now policy of the ABA, recommends similarly that the federal statute be amended to give the protection to courthouses that is extended everywhere else. There have been things that have been going on in response to this beyond that as well. There have been civil cases that have been brought. It's, you know, the relationship between states and the federal authority is complex. We had a case in Massachusetts in which an action was brought seeking a writ of protection for anybody who, specifically 8 people who didn't want to be named, but also anybody who's similarly situated, to protect them against the threat of arrest in coming into the courthouse. That was a matter that was dismissed by the single justice of our Supreme Judicial Court. She did not choose to issue this writ of protection, which I think Professor Lash will be able to talk us through a little bit of the background on, but it basically provides a common law protection against civil arrest in certain circumstances. But that didn't work. You know, so a lawsuit in that way was too broad. You know, we didn't have respondents. It was all ex parte. It wasn't something that courts were used to dealing with. Somebody coming in asking for the protection of the court without a case going on. And so that wound up being dismissed. And the court really also pointed out that it might not even really, that a writ by a state court, even if it was directed at a particular person, that would not necessarily prevent ICE officials from performing their duties as they see it and making arrests in locations where it would be safe. We think this is a very grave access to justice issue. We know of many instances where people have been not going to court, not going to churches when they see, you know, the ICE wagon there. Same kind of idea. I heard a terrible story, and I'm going to stop talking, about someone who lived in a Brazilian community in Massachusetts. And right by the church where all the Brazilians who were parishioners would go to worship on Sunday morning, right near there, suddenly was a big ICE wagon. We used to call it a paddy wagon. My ancestors had to get arrested. The Irish, they would go into the paddy wagon. And that was being used to arrest churchgoers. So, thank you.
Thanks, Kevin. And we'll obviously get more into it with following up and whatever questions the audience has. We now want to turn to a judicial perspective from Judge Langford Morris. And in the context of how the court views its responsibility in terms of what goes on in the courthouse, not only in the context of handling your own cases and the cases that occur in the courthouse, but also in the context of security within the courthouse itself in situations that might lead to confrontations and other situations that affect, obviously, the security of the people in the courthouse as well as those who are involved in those incidents.
Thank you so much for inviting me to participate with this distinguished panel. And it truly is an honor and a privilege. I want to get some idea, however, those of you that are in the audience, how many of you are actually practicing from the prosecution perspective or from the defense perspective? Let's start with prosecutors. How many prosecutors do we have? Or if that was your last work? Okay. And how many defense? Okay. And so do most of you practice in state court? I see heads shaking yes. Okay. Well, you heard that I'm a judge. I've been a judge. I'm in my 27th year on the bench. For 27 years, I've been hearing both civil and criminal matters. The first 8 years, I did civil, criminal, and family, and appeals from all of the district courts and state agencies within the jurisdiction. I'm in a county that's just north of where Detroit is. We're almost 1.3 million people in my county, so it's a very busy court, and I have the honor of serving the citizens of Oakland County. So I just wanted to put that in perspective. As a former USA, I did defense work mostly for the feds, Bivens actions, and representing defense agencies and agents. I'd like to start out in Michigan. I guess we are pretty blessed, having listened to Kevin, and we had a chance to talk a little bit about this at a conference where we were previously. And it appears that in Michigan, we do not have the interference from ICE in my courthouse. I haven't seen it, and I've done some research knowing that I was going to appear on this panel, and I've been informed by the captain of our court security, the deputy in charge, that we have never had ICE come in and actually remove someone from one of the courtrooms. There are about 20 judges in the circuit court. I also checked with my chief. I'm the dean of the bench, but I checked with my chief. I had her check, and no one has ever complained about this. So we've been lucky. We have had maybe 3 ICE agents within the last 3 years that have entered, went into the courtrooms, and actually observed a proceeding, but not interfered. They just came to observe. And I think that you know, and we all know, that immigration issues are paramount today. And so as a judge, I have always taken it seriously, even before it became so premier of an issue for judges to ensure that people's rights are protected. I've had cases for many years. We have a huge Arab community in Detroit, the largest Arab community. We have Christian Arabs and Muslim Arabs. We have they're Chaldeans, is what we call the Christian Arabs, from Iraqi. And Iraq will actually, they tell us that you could possibly be murdered if you're returned to Iraq. And so it is a very serious offense when people are in our courtrooms, either as defendants or witnesses. We do not want them to be interfered with, whether it would be by ISIS or anyone else. Everyone in a courtroom should have the protections of fairness and justice. That's my job. I am the judge to ensure that there's a level playing field within the courtroom. And so, for example, when I take a plea, in the recent years, I started adding more detail to the plea-taking process. And I've had lawyers ask me for the script as to what I'm saying about the immigration issues. So you all know all the basic rights that we give to a defendant when they are giving a plea. However, I want to just share with you in the advice of rights what I tell criminal defendants and I tell this to every criminal defendant, not just someone that has an interpreter. I don't look at a defendant and try to determine if they're an immigrant or not. You don't know what an immigrant looks like. I've had immigrants in my courtroom from Canada, from London, Russia, everywhere. You can't look at someone and determine they're an immigrant. So every single defendant, this is what I tell them after I get to the point in the advice of rights where I'm dealing with the immigration issue. I say, do you understand that if you have any immigration issues, there could be consequences? You could be deported. I cannot give you any legal advice or any immigration advice. I have no control over the immigration courts, and immigration law is changing daily. In addition, I ask them, do you need time to consult with an immigration lawyer? Assuming they say no, then I ask, are you ready to proceed with your plea, whether it's no contest or guilty? And then I get to taking the factual basis. But if there's any defendant, whether they're an immigrant or not, if they hesitate on rendering a plea, I'm going to give them an opportunity to consult with their attorney. I'm going to pass it. I will adjourn it. You can come back next week. If you're in custody, we can adjourn it 1 week for the next in custody proceedings in my courtroom. So having shared that, we haven't had any ICE agents actually appear. But I think it's important that I would be prepared if in fact that were to happen, because we have to maintain the integrity of a courtroom. We cannot have witnesses or defendants or victims or anyone feeling intimidated when they are in a courthouse, whether it's a state courthouse or any other kind, in my humble opinion. And so I have had many cases where witnesses were afraid. I've had cases, gang murders and cases where double gangs were victims gang and defendants gang members, and we have people, we have Hispanic gangs, we have all kinds of gangs in my county. And so what we would do is we have had what we call material witness warrants, where sometimes the individual would have to be arrested because they were terrified, they didn't want to speak, and the prosecutor would come in and ask for a material witness warrant. I did it myself as a former prosecutor. Sometimes you do have witnesses that are afraid, but you don't want to go that far as a prosecutor if there's anything else you can do to protect your witness. And the same thing I think applies to defense counsel. If you can protect your client, then you want to do whatever it is that you can do to protect your client. Now, I just want to share a couple of instances that I've been involved with. I know for a fact that we have had, I don't want to name any names, but we've had lawyers that were actually, there was an attempt to arrest a lawyer in my courthouse due to federal taxation, tax cases issues, and they sent the marshals. The federal judge sent the U.S. Marshals to pick up the lawyer in the courtroom while he was handling a criminal matter. It wasn't in my court, but in my colleague's court. And she immediately refused the U.S. Marshals from taking custody of the lawyer, which was her right. And she had the deputies on notice that you are not going to allow the marshals to take this lawyer. He's with me until this case is completed. And so I think that that's one example of what can be done in protecting, whether it's the lawyer, the defendant, victim, witness. You do not have to allow any of them to be taken from your courtrooms. Now, I know that there's always the possibility that dealing with a large court complex, someone could be arrested, if you will, or taken into custody when they're in the courthouse someplace outside of my view or outside of the building. And so that's an issue that we, as a bar association, are going to have to probably address as things proceed and as things change with immigration law. And I think that's why many of us are here and active with the American Bar Association, one of the best bars in the world. And we know that there are issues that will arise and we have to address them. Now, I want to share, we did have, and I'm going to just wind up in just a couple of minutes. It's a dangerous thing when you give a microphone to a lawyer, much less a judge. But there really is, there has been some high-profile cases in the Michigan area where we had approximately 40 Chaldeans, Christian Arabs, arrested. And they had prior convictions on their record. There wasn't anything major. Some of them have had minimal convictions, maybe drunk driving or who knows, very minor criminal convictions. But maybe they were doing well in the community. These things happened a long time ago. We did have a circumstance where 40 were arrested and they were going to send them back to Iraq. Well, my probation agent that's actually assigned to my courtroom, he's there with me all of the time when I'm handling my criminal cases for arraignments, pretrials, pleas, sentences, and violations of probation. He is also the pardon investigator for the state. And he shared with me today, in fact, that he was the person that the governor's office came to go through those 40 Iraqi citizens, and the last governor in Michigan actually pardoned them. And that's a big deal, because if you are pardoned, that governor left at the end of December. He was a Republican governor, and he pardoned the 40 Iraq citizens. And the point is, if you have a expungement of a conviction on your record, according to my agent, he says that ICE will still proceed. It has to be an actual pardon in order for it to disappear. And even then, I understand that you still have to go in front of the immigration courts to ask that whatever it is, the proceeding actually get dismissed after post pardoning by the governor. And so these are all factors that we as litigators and as judges hearing litigation have to concern ourselves with. So that's kind of the perspective in Michigan. I think we're lucky that we do not have this going now, but we are working on being prepared at all times.
Thank you, Judge. And you shouldn't worry, I've spent my whole career trying to discipline myself not to interrupt judges. So with varying success. Anyway, but now, Chris, Professor Lash, if, okay, and if you could sort of give us a legal framework, as Kevin mentioned, some of the underlying constitutional issues, and also how this is playing out across the country, and a little bit about what you and your colleagues have been doing in the sense of what motivated that 300 professor letter and what was in it, and whether it's had an impact, and where you think we're going across the country, because I think you probably have the best sense of the broader context of the issue right now.
Thanks so much, and like the Honorable Judge Morris, I want to express my thanks for being here. It's a privilege to talk to this group, and especially to be up here in such esteemed company. So thank you. I want to pick up on some of on Judge Morris's example of the U.S. Marshal coming to the courthouse and being told, no, not in my courtroom. So I think that there's a lot of interesting issues that are swirling around this issue of immigration courthouse arrests. Federalism is one. Can we as state officials tell federal agents that they can or can't do anything? The sanctity of the courtroom and the courthouse is another, and I think you were very careful to say the courtroom is one thing, but now if we start thinking about the courthouse and its environs, that could be something else. So I have written for a long time and been involved in what could loosely be called sanctuary issues, particularly the use of immigration detainers to transfer people from state and local custody into federal immigration custody. And so being sort of tapped into these issues, and there's been a lot of movement on that particular front over the last 8 years or so, and particularly the last 4 years, where sort of the pipeline, if you will, from state and local criminal systems into the federal system has been shut down or narrowed. It's not as easy for federal immigration officials to obtain custody over people who are in state and local criminal proceedings as it once was. And as that has sort of been shut down or tightened a little bit, you see like as if you were squeezing Jell-O, it's going to appear somewhere else. And on a certain level, you can maybe think about the courthouse arrests that way. In early 2017, early into the Trump administration, people were very concerned. I was at a community meeting in Denver, and it was, I believe it was shortly after Trump had issued his executive order on day 5 of his administration, that essentially said, I'm going to cut funding for any sanctuary jurisdiction in the country. And the people in the community were very concerned. Was Denver a sanctuary? Wasn't Denver a sanctuary? What was going to happen? One person stepped up to the microphone and said, is it safe for us to come to court? And some city officials immediately responded, yes, it's safe for you to come to court. And that's maybe where our story begins here. If I can, yes, I can. It's not, and it was not in Denver. ICE had been coming to court, and this slide here shows an attorney on the left. This is an attorney with the Meyer Law Office in Denver. She's talking to a couple of undercover people who admitted on questioning that they were in fact ICE agents and they were there to make an arrest in the courthouse. This video got put up on YouTube, and then people really started to worry in Denver. A brief thought experiment, the colloquy that you described that you go through with criminal defendants when you take a plea, imagine maybe we have to push that colloquy to the front end of the entire proceedings and say, what you need to know before you engage in these proceedings is anytime you come to the courthouse, you may or may not be put into deportation proceedings, right? So this is a huge issue, and one of the initial responses, as Attorney Curtin alluded to, was chief justices from different high courts of different states began objecting. So a letter from the Chief Justice of California, from the Chief Justice of New Jersey. In the city and county of Denver, it wasn't from our Chief Justice, it was from our mayor and a group of I think the entire city council, I think the DA, I think the city attorney also signed that letter. Oregon, also Connecticut, I don't think I have the letter up here. So all of these different groups are saying to ICE, basically, would you please stop? The response from, this was then Attorney General Sessions and then Department of Homeland Security Secretary Kelly. One of my scholar colleagues has a nice way of describing this first paragraph in which they sort of took the Chief Justice of California to task for using the word stalking in her letter, and they decided to mansplain that stalking is a legal term and it has a legal definition, in case you didn't know, Chief Justice of California. The second paragraph here puts this in the sanctuary, in the context of the sanctuary sort of ongoing battles. Because one of the reasons that ICE has given for why they need to make these courthouse arrests is because they can't get people from the jails anymore. So therefore, and they describe this as localities basically hindering immigration enforcement. So, and here's the response to the letter from Denver, is more courthouse arrests. I don't know, how many people find this picture disturbing? A lot of people. And what I'll say is, there's something about this that gets to a lot of people. Many people are troubled by this idea that arrests like this are going to take place in courthouses. And so I, as a scholar, sort of started trying to think through this. And of course, my first thought was, we got to go to Blackstone, right? That is meant to be funny. I mean, you came here to talk 15th century law, right? Well, Blackstone's 18th century, but he's talking about 15th century law, thank you. But the way I got to Blackstone is thinking about something I learned in my first year of law school in Civ Pro, which was the idea about if you come in from out of the state to go to court, that you should have some immunity that you can't be served with a new lawsuit while you're in the state. And actually, if you trace that doctrine back, you find this 15th century privilege from arrest. And it was at a time when civil cases were started with arrests. The arrest would be made by a sheriff in England. And the doctrine was, you can't be arrested in the courthouse or near the courthouse. And you can't be arrested on the way to or from the courthouse. I won't go through the whole doctrine, but what I'll say is it's got basically two strands. One is this idea about protecting people who are coming to and coming from the courthouse on their business in the courts. And the idea there is a very simple one. We want people to be able to come to court. We want witnesses to be able to come. We want parties to be able to come. We want other people who are interested in cases to be able to come. I would hazard a guess that in our current day, with our current Constitution, we might want the public to be able to come and go to the house. It's a value of transparency. And it's access to justice. And then, but there's a separate strand, and this I think sort of goes to this idea of not in my courtroom, which is this strand about the specialness of the place of the courthouse and its environs. And I want to just share with you this one case that I can't really get over. This is Orchard's case. And really, I'm the bottom paragraph here. So, officer, so what happened here was that, oh, this is hard to work. I got to keep my finger on it. No, that's all right.
Oh, yeah. You don't need to do that with this one.
Well, thank you. I'm in such nice company. Thank you for taking care of me. So the officer in this case arrests a person in the courthouse, and the person seeks their discharge, basically a habeas corpus case. And the court examines the officer, and the officer says, "Here's what happened. I saw him. I hastened to arrest him because I knew that that there was a warrant out for this person. He ran for the courthouse and made it inside the outside door of the courthouse." And what do you think the court does? Reprimand the sheriff, right? I think it's a great illustration of how strong the protection and the sanctity of the courthouse was held in that time. So those are the two strands of the privilege, and I think I'll just stop there because I think we're going to have a really interesting discussion. Thanks.
Great, thanks, Chris. All right, so I have a couple of questions, and I want to pose some of them to two of our panelists. Let me ask Kevin first, and then obviously I'll get to all three. But there's some that I'd like to ask first, the prosecutor's reaction and the judge's reaction. But the first question I have for Kevin is, I guess as a lawyer, as a litigator, my first reaction is, can you negotiate with ICE? Or is that counterproductive, and in the sense that you're just giving them a heads up that someone's going to be there they want? So what's
That's a great question, and the answer is yes. Prosecutors negotiate with ICE all the time about trying to get people to come to court, getting them out of ICE custody into the custody of some state official, and then ensuring that the person's going to be returned to ICE custody afterwards. There's no reason why there couldn't be such collaboration. Well, I'm not saying the prosecutors, state prosecutors will enlist to be agents for ICE for enforcement purposes, or because that's very different. But in terms of negotiating about, well, because even under the ABA policy, if there is an exigency, then they can make an arrest in the courthouse. But if that's going to happen, that should be so unusual and so special that the Chief Justice of that court certainly ought to be notified, so that the appearance to the if nothing else to the public is that justice seems to be being done, and it's not a naked battle of sovereignty between state officials and federal officials, each of whom is only doing what they think is right. So this actually spookily recapitulates an incident that actually happened. I'm in our Superior Courthouse in Middlesex County all the time. I don't try cases there, but I'm always there. And so one time, this is a little bit a year ago now, a prosecutor comes into my office and she's complaining. She's complaining because her witness has been arrested. And the case is on for trial, and she needs this witness to go forward, and what should I do? And so I said, well, you're a prosecutor. Ask the judge. She's there to help you. Get a continuance. Explain what happened. And so she said, oh, okay, all right, so I'll go and I'll ask the judge for a continuance. We're scheduled to go to trial today, but I'm sure that she'll be happy to give us a continuance. And that was all that I heard about it until 4:30 when I found out the case had been dismissed. So that, from the prosecutor's perspective, this is just really bad policy. It's also wrong, I think, morally, almost like spiritually. We have this idea that the law is above people, and that there is like this transcendent idea of justice, and that if we go to this place, justice is going to happen there. Not just naked exercise of power, but that people can go there and they can be vulnerable, they can submit themselves to everything that goes along with being a victim in a criminal case, everything that goes along with being a person who has to come to court and endure cross-examination, perhaps, endure the inconvenience, but we do it because we think that there is a higher good that is being accomplished, and that this is a special place. So for prosecutors, we are horribly offended. And it's not just the inconvenience of having cases be, especially terrible domestic violence cases, be dismissed because we can't get witnesses to show up, which happens all the time. We can't get witnesses to talk to police officers because they're afraid that they're going to become witnesses and then going to have to show up in court where they are afraid to go. So from the prosecutor's perspective, what happens without collaboration, such as it's going to be, say that in a special case, we need to make this arrest in the courthouse. All right, go ahead and explain that to the judge. Maybe there's such a case where that's going to be appropriate. But, you know, that should certainly be the exception.
Judge Langford Morris, let's say either side of it, let's say a prosecutor, like Kevin, or one of the people he supervises, comes to you and says, our main witness is afraid to come to the courthouse because of ICE enforcement, and we'd like an adjournment so we could try to alleviate the concerns or whatever. Or a defense attorney comes in and says, the reason my client's not here today is because they heard someone got arrested at the courthouse. And it would happen in your courthouse, obviously, that you mentioned, but let's say in another, if you were a judge in a courthouse where it did occur, and they said, the defendant is afraid because they heard that someone got arrested in the courthouse for showing up, and the defendant is just afraid to show up, and I'm asking you not to warrant the defendant. And what do you think your reaction would be, and how do you handle something like that?
Well, actually, I've had cases where the prosecution and defense have asked for adjournments, sometimes at the last minute, when the trial is scheduled the next day or that day, and we haven't selected the jury yet. I pretty much try to work with the lawyer, and we have some really excellent lawyers in my jurisdiction. And I will say this, Kevin, we don't have the situation where I'm dismissing cases because witnesses can't appear. In 27 years, I maybe can count on 3 fingers, maybe 2, and I'm hearing approximately, well, in the beginning, we would get over 600 criminal cases a year. We're not getting quite that many, but a lot of criminal cases over 27 years. And I can't even remember dismissing because they couldn't get a witness. They usually can get the witness, and I'm in a jurisdiction where the prosecution as well as the law enforcement officers are really known for being tough on, and they will find you. They basically have a lot of staffing. As I indicated, I'm in the county just north of where Detroit is, and so there's a lot of resources available, and they will find the witness. And even with domestic violence cases, as long ago as when I was a prosecutor, back then, the law in Michigan was such that even if you called the police came to your home, they arrested the defendant, and let's say the woman didn't want to testify. We've had people that were running naked in the street to get away from the defendant, and then they changed their mind and didn't want to testify. And whatever excited utterances they made at the time they had initial contact with that officer, those would be utilized, and you could get a conviction in Oakland County with a jury with no victim testifying. It has happened. And I'm talking about way back to when I was a prosecutor in the mid-'80s. And they're just tough.
I wish I was practicing in front of Judge Langford Morris, because we actually do have cases dismissed for lack of prosecution every day.
Yeah, I mean,
Every day, and it's not under these circumstances.
so I would just say this, with whether it's the prosecutor or the defense counsel, I have enough to do. I'm a really busy judge with civil and criminal cases, so it's really not that hard for me to grant an adjournment or stay the case for a short period of time. We don't have lengthy delays. That's the other thing that we have that's paramount. I cannot sit on a decision longer than 35 days. A criminal case is supposed to go to trial after 91 days from arraignment in front of me. So 91 days, you're supposed to do the trial, or up to 1 year, but no longer than that. So we're moving the cases along, and they are taking account of every single thing that happens in every single case in my courtroom and everyone else's. Every single month, we get a detailed report as to where the cases are, age-wise and otherwise. So I'm just saying that every court is different, every jurisdiction is different, I know that, but I don't have a problem working with either one, whether it's the prosecutor that needs a brief adjournment or the defense counsel, if there's an ICE issue, I'm going to give them a chance to work it out. I want them to take that chance to work it out before they come to me and ask for a material witness warrant.
Chris?
Yeah, so the interesting thing about the privilege that I unearthed with this research is that on the one hand, it was deemed to exist regardless of any action taken by any of the parties. So if you were arrested on your way to court, you were entitled to your release pursuant to the privilege. But there was also there's also a line of cases that talk about something called a writ of protection, and that's a writ that the court could issue that would basically be a piece of paper that the person could then carry, and if anybody tried to arrest them, they could say, look, I'm going to court, you can't arrest me because the judge says so. The Massachusetts case that Attorney Curtin referenced earlier, the single justice case, was an attempt to get a writ of protection, I would say sort of on a class action basis. And while that was denied in the particular instance, and I would say on largely procedural grounds, the court recognized that the privilege seems to be well established in Massachusetts. And I think you can almost read that decision as directing attorneys to go to their judge and ask for a writ of protection on an individual basis. The power to issue the writ was deemed inherent in the court because it's in the interest of the administration of justice. So it's like a court's authority over their courtroom.
So I see we have Wendy Wayne, who's our chair, the chair of our Commission on Immigration. She's also a great defense attorney here. She filed that suit in Massachusetts. Hello, you thought you were going to escape us. So she filed that suit in Massachusetts, and I'm going to say we, because because my district attorney wrote an amicus letter in support of this lawsuit. We lost, but if you read the case, it's clear that the recognition, as Professor Lash has pointed out, the judge didn't want to dismiss it. She sees the inequities, but she just couldn't issue a writ without a person to give it to. The procedural posture of that particular case was problematic for her. But it's great. It's good. And if anybody wants a copy of the decision or the pleadings in that case, contact me or Wendy Wayne, and we'd be happy, I'm sure, to share that public information with you. And I mean, clearly, this is something we don't want to see this happening. So what do we do about it? Is the problem where we're at right now.
Yeah, and that's actually one more question for the panel, and then we'll open it up for the audience. But and I'd like to work from Chris to Kevin to Judge Lankford Morris on this one, which is solutions in terms of some of the solutions that are out there, some of that are in progress, and which do you think are the most effective, but also which are the most practical in the sense of getting something through the U.S. Senate at this point is problematic. But in certain in states, for example, New York State, as Kevin mentioned, New York State passed a law last year, but it was only by the Assembly, which is traditionally Democratic, and the Senate is traditionally Republican. Well, now, after November, both the Senate and the Assembly are Democratic, and the judge is a Democrat, and the prospect for success of that legislation is significantly enhanced at this point. So we'll see what happens, but and then you have court-oriented. The New York City Bar has recommended to the Chief Judge of New York to issue rules to cover this with a series of very detailed recommendations. So I would like to know where you think there are solutions that can be effective and practical at the same time. And practical, what I mean by that they can either pass a legislature or be implemented in a way that can protect the integrity of the judicial process as we've been talking about.
Well, I want to offer up a disclaimer because I'm an academic, so practicality is not in my wheelhouse. But I actually think that the body of law that we're talking about here is a great tool for both local courts, state courts. I think for me, the power of a local court, a local chief justice, a state chief justice to do this would be very difficult to question. I know we're going to get into federalism, right? But just as I think the U.S. Marshals didn't insist on their ability to make that arrest in the courtroom, and I think that for ICE to insist on their ability to make arrests in courthouses would be kind of similarly perilous for them. A piece of the work that I did was looking at because the privilege from arrest is rooted in the court's authority. Federal and state courts alike recognize that, and so I think that if a state court judge or a state court chief judge had attempted to enforce the privilege, and ICE was just disregarding that, I think there would be a sympathetic ear in the federal courts. I'll also just quickly say I think legislation is also, and not on the federal level, but because that seems impractical. But I think legislation at the local level, so in Denver, for example, the city council passed an ordinance in late 2017 that effectively prohibited city workers from communicating immigration status or immigration-related information to ICE. And that applies to the courthouse staff too. So if someone's calling up trying to figure out when somebody has a court date for the purpose of making an immigration arrest, I think that would apply. And then I also just want to quickly mention that in New York, well, to step back on the legislative side, I think the legislatures have the authority to effectuate this authority of the courts. I think if legislatures tried to limit it, then you would run into a separation of powers problem, because I do think that this power is basically in the courts. In New York, the governor issued an executive order saying no ICE arrests in executive offices in New York. And I haven't heard anything about any kind of a legal challenge brought up against that. So it seems as though the ability to control state government.
So from my perspective, I can see a little bit of both sides. You know, the problems can be illustrated by two examples. You say you've got a case where the judge finds out that ICE is going to arrest this litigant. Say it's a petitioner seeking an abuse prevention order. You know, for me, the worst kind of case, someone who goes seeking justice in this house of justice, risks everything to walk into one of our buildings. And, you know, what should be the role of the state in helping these ICE officers enforce basically civil law where it is going to create a situation that is going to cause a likelihood of injustice in particular cases, and certainly develop, this is not what we want the public to see. If we want the public to have faith and trust in our legal systems, to see squabbling. So say a judge decides, well, I know that this person's going to be arrested by ICE. I don't want that to happen. I'm going to smuggle her out the back door. Okay? That's a scenario that happened recently in Massachusetts. And contrast that to a situation where judges are basically co-opting court officers in to act as agents for ICE to hold people who would be otherwise at liberty to leave the building until an ICE officer can show up to arrest them on this civil detainer. So what is the role that state court judges and prosecutors can play in this? To me, I don't really like the idea of smuggling witnesses out to avoid them being arrested, where there's a lawful arrest that could be made. And, you know, I think that that's sort of going a little bit too far in terms of comedy and appropriate respect for the roles of sovereigns. But that, you know, that's so rare. The vast majority of cases that I see are cases where people are afraid to come to court. They won't participate in the legal system, and we don't get justice done in particular cases, and we don't look like we're doing justice in particular cases because people are afraid. They're afraid because and legitimately. So what should be the role of the courts, state courts, in fighting against this? I think that the judges have great authority to preserve the legitimacy of their own process. And to the extent that we're seeing things like this, I mean, there's no machine guns, you know, at the Middlesex Superior Court. We don't enforce the law by force there. We have a process where this goes on. And if in the middle of that you're seeing brawling taking place, or people taken into custody, you know, contrary to what appears to be the rule of law, that is such a grave problem. And now we really need to worry about trust, and the public having trust in the legitimacy of our legal systems.
Judge?
Well, let me say again that I'm really pleased that we haven't had this issue in my courtroom and in my courthouse at this point. But I do think that we have an obligation as jurists and as lawyers to try to get ahead of what's happening to the best of our ability. And so we need early intervention in getting with our legislatures within our various jurisdictions at the state level, and to talk to them about these things that are going on in New York and elsewhere, so that they're aware and we can start with legislation that might be helpful. As a state judge, our powers are limited to what goes on in our state. We're not federal judges, and federal judges have their powers where they sit. As I understand, the district court and state court, circuit courts at any rate, it's a concurrent jurisdiction situation. So in our courtrooms, we can protect. But then, as you mentioned, Professor, we really have to look at going to the courthouse, leaving the courthouse. We would have pandemonium if we had witnesses and victims and defendants all terrified to come to a state courthouse. It's the state courthouses where the bulk of the criminal cases are handled. It's the state courthouses where the heinous crimes are handled. We're the ones handling human trafficking, rapes, murders, robberies on a daily basis. And so it is imperative, in order to have law and order in our communities and in our jurisdictions, that our courts work. So I would say that the actual working with the legislature and trying to get effective laws in place, that's one thing. The other thing that you mentioned, Professor, about getting early on in the process of advising one of the issue of possible deportation and whether or not they really need to meet with an immigration lawyer. Obviously, we need more lawyers to help in this area. There's a greater and greater need for pro bono help. There's only so many lawyers that really know immigration law, and they are working really hard in the Detroit area. In addition, I always see the issues when a person is apprehended. If you don't speak English and you're an immigrant and you don't really have anyone there to interpret for you, you're at an automatic disadvantage. You need the Miranda rights, but you need your immigration rights, really, from the onset of arrest. And so these are all things that would have to be changed legally, but we're on notice because we know that these things are happening in various jurisdictions in our country. So those are just a couple of things that I would say as far as possible solutions, but nothing's immediate. We can only do what we can do when it's happening in front of us. You didn't hear my. In Michigan, they came down with an appellate case, I don't know, maybe about a year or 2 years ago, that added that to the plea form, that just that you have to advise them that they need to consult an immigration lawyer. I do all of those. No script at all, nothing. But that's my script. And I do have lawyers that come, because everyone knows, like I said, I give it to every single defendant that comes in front of me, because I cannot determine who's an immigrant based on how people look. And so I get a lot of lawyers asking me for that script. But I made it up myself because I watch the news at night and I see what's happening all over the country, and I believe it's true that immigration law is changing daily. We don't know what's going to come down tomorrow. And so I want people to be fully advised before I accept their plea, because as a jurist, you know that we have to make a finding that the plea is knowingly, voluntarily, and accurately made. And I take that calling very seriously. I'm not going to conclude that unless I'm positive that it truly is. So if I have any hesitancy, whether it's an immigrant or not, I'm going to give you time to think about it, talk with your lawyer. If you don't want to proceed with the plea, that's okay with me. I like trials. I'm happy to give people their day in court. I was a real litigator as a lawyer. I believe people are entitled to their justice in the courtroom.
Just to jump on that just really quickly. So the Padilla right and the constitutional law around Padilla, I think we all know, has had to be enforced on many different fronts, right? So it took a lot of education of the bar, but judges have an important role to play here, and prosecutors as well. We're seeing a lot of new policies about prosecutors taking into account immigration consequences. And I would just say, maybe the sanctity of the courthouse is going to be something similar, right? Maybe it's going to need judges giving advisements at arraignment. If you are concerned about coming to court, you can seek an order from the court, and maybe making that known to different segments of the.
Well, there have been instances across the country of lawyers who have been involved in altercations or confrontations with ICE, and I think that there's a the results have been varied in that context. But you know, as a criminal defense attorney, there is no script, certainly, and there hasn't been a lot of guidance in terms of what to advise clients. I think the most important aspect is full disclosure to clients, and also perhaps to alert others in the system who are not going to necessarily take advantage of it to put your client in custody through ICE. So.
I don't think the problem is really about arrests in the courthouse. That's been done for generations. Many, many times, a person comes to court, citation, is arrested in the courthouse. Sometimes they go out and shackle, sometimes they don't. The cases you're talking about in the Blackstone, I think are probably civil cases. Debtor's prison, body writs, due process, what have you. And so it's not, what really stinks here is our immigration policy. I mean, it's not the procedures that's the problem, it's the substance. And we're doing things to people that we shouldn't be doing to them. And that's where we're gonna, I mean, we can talk about all sorts of techniques that alleviate that, but the real problem we gotta face is that's where it's at.
You know, I sit on the bench in New York, just north of New York City. I'm a part-time judge, I'm a full-time client. We give the warning similar to Your Honor's warning, three times. At arraignment, at plea, and at sentencing. 3 times they're warned about the possibility of there being an immigration impact. Additionally, and this was decided by the judges in my court, in the court I sit in. Additionally, we never, ever ask someone if they're a United States citizen. We don't want them to ever answer that question. We tell them, if you're not, there might be the immigration. I just think that we have to be very, very careful that judges don't step over the line from being neutrals to advocates. And the way you do that is you make the defense counsel responsible to take care of his client, his or her client. Now, in New York, we have regional groups that advise attorneys as to the immigration impact of a particular case. You can take your entire case and send them the rap sheet, the charges, and everything, and they'll evaluate, immigration experts will evaluate that particular case and give that lawyer advice as to what the immigration impact of that case is. The lawyer has to represent the client. The lawyer has to protect the client. The judge is a neutral. The judge's job is notification. Not to step over that line, because then you have problems of the justice system looking bad and indifferent.
So can I just respond to that, or make a comment on that? So that's, what I like about Judge Langford Moritz's advice is that it goes beyond the basic, Padilla warning or whatever is required by statute in most jurisdictions, and says, I'm going to give you more time if you need to talk to an immigration attorney about this. And that's different, that's better.
We do that. And I'll adjourn the case at sentencing.
Yeah, that's
If
good.
the defense counsel says, you know what, Judge, it's time for me to talk to the immigration attorney.
Yes.
You should have done it before this.
So this,
You're going to get a short adjournment for that purpose.
but, and this goes back to Elizabeth's first couple of questions just now about how do you advise your client as a criminal defense attorney about these immigration consequences and about the decision to come to court or not. These are it puts a lot of pressure on criminal defense attorneys to know a lot more than they maybe have been trained to know about the consequences of this particular case on whatever your immigration status is. And but it's hard to see how that advice is going to be made accessible to the client in any other way. So, how do you advise? Should I ask that bail be put on you in this state court case so that you're not deported? Should I, as a prosecutor, not request bail in this case, this weak case, say, knowing that without bail he's going to be deported, and that, or in a case that we're not asking for jail time, do we want to ask for bail or not ask for bail based on, projections about how immigration might affect, my case? Or it's very difficult to know, but there's nothing wrong with the defense attorney I think, talking with a client and making a decision to let that person stay in state custody, say, for the dependency, so that this, in other words, ask the judge to revoke bail, because otherwise he's going to go to ICE. Very hard. We have. It's hard.
My experience more recently is, I'm not a public defender, but there are, and probably Stan's office for sure, and I know even federal defenders' offices in the New York area have now poached immigration experts from a lot of immigration organizations to be on staff to answer all of those questions and to be a full-time advisory resource. And that's critical, because the whole context of the whole, collateral consequences for so many cases have overwhelmed the formal punishment that defendants face, and immigration is foremost among them for most clients. So, Chris, what's the status? Because I know some of that is in policy.
So I don't know how much I can respond to, so my work around sanctuary has really focused on the criminal and immigration intersection, so I've been not as focused on hospitals, though I think hospitals, if we're going to go back to medieval times there too, we're going to find them being connected to churches, and churches are connected to sanctuary, and there's going to be some really interesting research that we could do. But what I wanted to quickly say is, so the places that you mentioned are in the current sensitive locations policy by ICE. And I think that policy really reflects a societal judgment, right? And the question, I think, when you come around to courthouses as well is, because we could easily say, well, the person is subject to immigration arrest, so why do we care where they get arrested? But the reason why we care is we value other things equally or more so, like the ability to get health care, the ability to go to school, maybe the ability to go to court and get exonerated on this case that you've been accused of. So I do think that, to bring it back to my fellow panelists' comments, I do think we're talking about a moral value question.
I agree with that too. So that your question really does fall into amending the federal statute, but it's really part of this larger question of what kind of a policy do we want to have on immigration, the enforcement of violations of immigration status. We do not have a coherent policy, in my humble opinion, that is consistent and that reflects our community values. And as the result of that, this is the type of conflict that we're seeing.
I just wanted to weigh in on the whole advising of immigration rights. As you know, immigration law is very complex, and the average criminal defense lawyer cannot advise on immigration law. It can twist on the smallest of facts. And so it takes a detailed conversation by a skilled lawyer that understands immigration law to meet with that person, and that's why I give them that opportunity. Now, most of the time, the lawyer that's assigned to the case, or even if they're retained counsel, they have found an immigration lawyer if necessary, and somehow that person has consulted with an immigration lawyer. But I would give them more time, and if it were a defendant who couldn't afford to go to an immigration lawyer, and he was being represented just basic indigent counsel representation. We don't even have public defenders in my area. We don't have a public defender office, is what I mean. We have individually appointed lawyers. Don't get me started, it's a long story, but we're working it out in Michigan. But the bottom line is, I think that I would caution about any lawyer trying to give advice about immigration issues and just say that we need to do something to ensure that an individual's rights are protected. We've got to maintain the sanctity of our rule of law here in America for everyone.
Thank you, and thanks to all of you. We're out of time. I want to give the panel.